Good evening. Item 15 on your agenda is the proposed anti-discrimination ordinance, and we're talking about introducing that tonight and scheduling a public hearing for your first meeting in June. As we introduce it, we thought it would be good to explain the intent of the ordinance, give a brief explanation of the ordinance, highlight what it does, point out what it avoids. We're not going to go through the ordinance in detail, line by line. It will be available on the website, as will this presentation for people to look at. Last fall, community proponents provided a draft ordinance to the City Commission. In a series of work sessions, the City Commission worked through that ordinance with the administration and legal staff to come up with our own draft ordinance. That draft ordinance is now being introduced tonight, and at least one public hearing will be scheduled. The intent of the ordinance is to provide basic employment, public accommodation, and housing rights to all persons. It expands the protected civil rights under state and federal law to include sexual orientation and gender identity as protected classifications. We are trying to strike a balance among competing concerns by respecting First Amendment rights, including religious rights. It's significantly different than the draft initially provided by community proponents. It's a shield against discrimination, not a sword to require action. So preferences are not required and preferences aren't allowed under the ordinance. It adds sexual orientation and gender identity to the characteristics protected by civil rights laws. It's applicable only to employment, housing, and public accommodations, because other classifications such as race, national origin, religion, and so forth are protected by state and federal laws. This presentation will focus on what this ordinance adds to the protections under state and federal law. So we have typical employment provisions seen in the civil rights laws. It ensures basic employment rights regardless of sexual orientation or gender identity, and covers employment actions such as hiring, termination, compensation, work classifications, and promotion or demotion. For housing, it ensures basic housing rights regardless of sexual orientation or gender identity, and applies to all kinds of housing transactions such as leasing, selling, contractual terms and conditions, maintenance, repair, remodeling, financing, referrals, and other types of real estate activities. For public accommodations, it ensures basic rights and benefits to public accommodations regardless of sexual orientation or gender identity, so it ensures persons will not be refused service because of those things. It applies to all entities offering goods, services, or privileges for sale or otherwise to the general public. Public accommodations is the same under our ordinance as it is under state and federal law. It addresses indirect types of discrimination, such as through advertisement, collective action with coercion or conspiracy, retaliation against complainants, and it addresses disparate effects. That is, you can have facially neutral policies that, when applied, have a disparate impact on some individuals. Now, there are exceptions in our ordinance draft, 19 to be exact, and those exceptions address many concerns about the possible effects and unintended consequences expressed about proposed ordinances similar to this in other communities. So we address practical concerns and we address religious concerns. Religious organizations are entirely accepted from the employment provisions, and religious organizations operating housing or public accommodations may limit those to those conforming with their tenants. However, if they offer those public accommodations or housing to the general public to a degree that they would lose their property tax exemption, then they will lose this exception under the ordinance and must comply with it. It ensures that the ordinance does not require a religious organization's violation of or prevent its compliance with its own tenets. The housing exceptions. They allow single-gender housing. You can have a girls' dorm or a guys' dorm, and you can provide housing for one gender or the other. It's inapplicable to rentals of 2 or fewer families if the owner resides in a part of the residence. So if you've got a duplex and you own it, you can rent the other side to whomever you like. It's inapplicable to the rental of rooms in single-family dwellings. So those who open up a room in their home to a college student or somebody else on a limited basis may rent those rooms without having to comply with the ordinance requirements. It doesn't apply to shared rental arrangements. So somebody who's rented an apartment or has a home and seeks a roommate can seek a roommate of a specific gender. You can still have age and student-related discounts, so senior discounts will remain legal, something that will be near and dear to my heart in a not-too-far future. Age classifications for teams, sporting events, and recreational activities remain permissible. Educational institutions may limit activities based on age or student status. So an educational institution can say, this club or this other organized activity is limited to those who are affiliated with the school. Gender exceptions, you can have gender classifications in sports and other recreational activities, so you can have girls football and boys football, girls cheerleading, boys cheerleading. You can still have those gender restrictions in the use of locker rooms, restrooms, and changing rooms. And the definition of gender under our ordinance focuses on the biological state, not on gender identity. So there's a difference in our ordinance between gender and gender identity. Other exceptions. The ordinance neither requires nor prevents employment benefits to be given to same-sex partners. City facilities and services will remain open to religious organizations and affiliated persons who disagree with the intent of the city ordinance. It allows but does not require city payroll deductions to charities that don't agree with the ordinance's intent. The ordinance does not affect government institutional policies complying with state and federal law. So if you have a state and federal law that requires that somebody be of a certain gender, that won't be affected by our ordinance. Private club membership standards are unaffected if they're truly private clubs, and family businesses may continue to employ only family members. Particular exceptions. The ordinance cannot be a basis for action against a student refusing to provide professional services due to sincerely held religious beliefs. Similarly, the ordinance cannot be the basis for action against an employee refusing to provide professional counseling services due to sincerely held religious beliefs. However, it does not prevent the application of the schools, the employers, or other professional standards or codes. It leaves those unaffected. Enforcement. Anybody who feels they've been discriminated against in violation of the ordinance may file a complaint with the city manager within 180 days. If the complaint is about a type of discrimination that's covered under state or federal law, the city manager will refer the complainant and maybe the complaint itself to the appropriate state or federal agency. The city manager may investigate personally or delegate that investigation to a city staff member or the city attorney. The city manager may refer the matter to binding conciliation or mediation. The city manager may refer the matter to the city attorney for a municipal civil infraction prosecution, or the city manager may decline to pursue the action and notify the complainant. Remedies. You have the remedies that can result from conciliation and mediation, and a violation of those remedies is itself a violation of the ordinance. There can be fines for civil infractions up to $2,500 per offense. The court may enjoin future violations, remedy past violations. Private lawsuit remedies, there's a private lawsuit remedy under this ordinance, and if a complainant files a lawsuit, he or she would be entitled to the same remedies as under the Elliott-Larsen Civil Rights Act. That's a state statute. And any city-issued license could be revoked for violation of the ordinance. A quick recap. The current draft of the proposed ordinance neither requires nor allows preferential treatment. It does not affect gender-based classifications for restrooms, locker rooms, or sport or recreational teams and activities. It allows religious organizations to restrict employment, housing, and public accommodations to those sharing their beliefs. It allows homeowners to restrict tenancy in their homes or duplex and apartment dwellers to restrict roommate selection. It allows the use of city facilities and services by and payroll deductions to those who disagree with the ordinance. It's a shield to protect people from discrimination, not a sword to be used to compel action by employers or those offering housing or public accommodation. The current draft of the proposed ordinance was intended to balance community interest. It protects persons from discrimination in employment, housing, and public accommodation, but it ensures that those protections do not unduly interfere with First Amendment and other rights. It's intended also to prevent undesired or unintended consequences that we've seen articles about and so forth with respect to ordinances in other communities. And the effort was to provide a thoughtful, purposeful ordinance that addresses the concerns in a sensible yet sensitive manner. And hopefully we've struck that balance in the months that we've worked through a few different drafts. I'm available for any questions or comments. And the ordinance itself will be available online, or the draft.
Any questions or comments from any of the commissioners? Commissioner Joslin?
Yes, Scott, thank you for your presentation. One of your slides talked about indirect types of discrimination. That's one of the questions that a lot of people seem to ask me. Can you explain that slide just a little bit more for me? Because you briefly went over it, and I didn't grasp everything on that one. It was under the additional applications.
Right. There are indirect types of discrimination, such as through advertising, where you're not discriminating per se, but you haven't taken the discriminatory action, but you're advertise a house or an apartment for somebody who in violation of the law. Your advertisement might be in violation. You can have indirect discrimination in coercion. You can coerce somebody not to take an apartment, for example. We see it in housing quite a bit. You can have a conspiracy with others to deprive somebody of an opportunity. In housing, for example, that home might be available. All of a sudden somebody discovers that the applicant is gay or the proposed tenant is gay, and all of a sudden, oh, I leased that 10 minutes ago, kind of thing. So it's the indirect discrimination that occurs, or certain types of individuals or organizations they refuse to deal with, and so forth.
Okay, thank you. Appreciate the clarification.
Any other questions or concerns by any of the commissioners? I just wanted to ask, there was one point, Mr. Smith, where you were talking about sports teams, and there was nothing in this ordinance that affected whether or not you could have a girls' basketball, boys' basketball, that kind of thing. But that would not have any effect on Title IX, for example, right? This federal and state law takes precedent over
Right.
our
It doesn't
ordinance.
impact Title IX, but what we're saying is that we aren't doing anything under this ordinance with respect to sexual orientation or gender identity that would prevent a school or a sports team from classifying that based on gender itself versus gender identity or sexual orientation.
Okay, thank you. Thank you very much. If there's, Commissioner English.
Currently, there are no state and federal guidelines for anti-discrimination for gender, and my question is, even recently, I think the state of Michigan is now, this is surfacing a little bit, as it is nationally. If the state were to adopt an anti-discrimination ordinance of this nature, how would that impact ours?
Well, what would happen is if the state adopted an ordinance that also addressed these same concerns, of course, we couldn't have anything that we would have would be subject to the state law. So if the state adopted something that was more strict or provided more rights for persons based on the classifications of gender identity and sexual orientation, that would take precedent. If we got a complaint from somebody under our ordinance and it was covered by a subsequent state law, that complaint would be referred to a state agency and not handled locally. So if the state did that, it would probably largely supersede whatever we do here unless we give yet more rights than the state does.
Anything else? Thank you very much.